Thank you, Director. Earlier this year, on January 31st, the Federal Register published a rule for the ATF regarding pistol braces. So how much, I believe that rule, in that rule, you redefined the definition of a pistol with a brace to become a short-barreled rifle, and in my opinion, that exceeds the authority of ATF. That was not Congress's intent. How much did ATF spend in crafting and publishing the rule?
I don't have a specific figure that I can tell you how much ATF expended. I do know that there were over 200,000 comments that people from the public submitted in that rule, and that, as we are required to do under the Administrative Procedures Act, we examined all of those comments and actually took them into account in what the actual final rule would look like.
And yet, when ATF originally made the rule in 2012, they said that pistol braces did not convert a pistol into a short-barreled rifle. Then they changed that in 2015, right back to, no, you can't do this. And then in 2017, they said, oh, yes, you can. And now we're back to 2023, and now we're in 2023, and we're back to a pistol brace making a pistol into a short-barreled rifle. So very conflicting. A lot of time, I think, spent by ATF going back and forth, trying to figure out what I think they should not have been doing in the first place, and that is reclassifying a pistol as a short-barreled rifle, a pistol with a brace as a short-barreled rifle. Now, in this new rule, you say that people who have a pistol with a brace have 120 days in order 120 days to register them with the ATF. How can ATF justify that time frame? I mean, the Street Sweeper USAS 12 Striker 12 shotgun was reclassified as a DD about 30 years ago, so this is a similar situation. And that time frame was over 7 years. So, and you've got potentially 10 million to 40 million people that have pistols with braces. How can you say 120 days is sufficient time?
You mentioned that there were prior ATF rules, and I just want to say, Congressman, this is the first time on this topic that ATF has engaged in APA notice and comment rulemaking. People brought specific items
Fair enough,
to
they used
ATF
a
to
letter.
classify.
It was a letter back in 2012, and then a letter in 15, a letter in 2017. This is the actual first official rule. You are correct.
But what was happening during that period, which I agree to you, there were inconsistencies, and that was one of the reasons for the rule, is to try to clarify among those inconsistencies, because the products were changing, right, over time, and also you're right, there were inconsistencies. So with respect to the time frame.
Right, the 120 days.
Yeah, so as you know, because I saw you there, right, the day after the rule was issued, I went to Las Vegas and met with at the SHOT Show with the NSSF, with individual gun owners, had a town hall. We launched a very significant education effort and campaign where thousands of FFLs have had the opportunity to learn about the rule. We are trying to get the word out, and when
So do you or do you not think 120 days is a sufficient time?
I believe that if there are individuals out there who have these products, that they can begin the process. So in other words, if you, we're very clear, if you file an application, you're fine until we look at the application.
So you think then 120 days is sufficient time? Yes or no?
I think the way that we are doing this is a fair and appropriate way to have compliance with the National Firearms Act. Yes.
Okay. So what will happen to those who never heard of the rule after 120 days? I mean, you've got potentially millions of people here. That's a heck of an ad campaign.
ATF will continue to enforce the laws as Congress has given us. We will, of course, prioritize people who present a public safety threat to the community. And it is not the object of the rule to play gotcha with law-abiding firearms owners. I would say to this, but for individuals who do know about it and who are trying to decide what to do, you can check with us as to whether your particular item is covered.
Okay.
And also if you're
Director,
going...
let me ask you this.
Sure, of course.
Do you think it's acceptable for Congress to spend taxpayers' money on unauthorized programs?
I'm not sure I understand the question.
Do you think it's acceptable for Congress to spend taxpayers' money on unauthorized programs? That is, programs that agents or agencies that are not currently authorized by Congress. You know, is that acceptable? Do you think it's legal? If something is completely unauthorized? I mean, we have authorizing committees and we have appropriating committees. This is an appropriating committee, all right? Is it acceptable?
Respectfully, I think that's several levels above my pay grade. Obviously, Congress makes the decision as to the appropriations that it passes. There are authorizing committees. I know I'm appearing before an authorizing committee of this body. No, in a week or so.
Okay.
And so I will leave any back and forth between the authorizers and the appropriators above my pay grade in this body, which is, in my humble view, where those kinds of discussions appropriately occur.
Time of the gentleman has expired.